after the voters list.
I think additional.
Additional.
I just give you in.
So, from what was the original village and Peradhara, and shifted village is Lakus. You have brought in the list of 1990, 93, 97.
93 total list of Peradhara. 96 total list of Peradhara.
So 97, their names are not in the Peradhara list.
Yes.
But in 1993, but in 1990, their name appears in Lakusi.
I don't have a copy right now.
The petitioners have filed an additional affidavit bringing on record the voters list of 1990 and 1977 of village Lakusi to show that prior to 1986, the name of the petitioner did not appear in village Lakusi, and subsequent to 86.
Prior to 86, they were in Peradhara.
Please don't disturb. Please let me complete my order. If you read the order, I'm stating whatever you are trying to say. I'm not saying anything contrary to what you say.
Prior to 1986, the name of the petitioner did not appear in the in village Lakusi.
In village Lakusi. Whereas on the other hand, prior to 1986, the name of the petitioner appeared in the voters list of village Peradhara, but subsequent to 86, it did not appear. MSA Verma, learned counsel for the respondents in the Home Department, seeks for an adjournment to examine the opposite materials. This next week, list after a week.
I think we.
Yes, Mr. Ali.
In the reference, I have been through the textbook work and more better and other total has been shown. And in that deposition column, no, even them are into the reference. And
where is the bar under the law that you cannot be referred? See, your opportunity to explain your case will be given by the tribunal. And tribunal, you discharge your burden under section 9 and produce all relevant material to show that you are a citizen. Reference is if the referring authority has any doubt. Referring authority is not the adjudicating authority, that they will conclusively decide whether you are a citizen or not a citizen. If they have a doubt, the law requires to refer it to the tribunal. Tribunal will decide. So, why don't you produce, refer to the relevant materials which will indicate you are a citizen? 66 voters list. Which page? Which page?
30.
Page 30. Yes, please. Night page number
Is 30.
32. Gao and Haripara. And who is the father? Numan, son of Abdul Khalid. This is 1970. And how do you establish that the petitioner is son of husband?
It's program working. In 70 Utali Malo, it is C18 Malo. There of Martinga Angle.
381.
381.
Motier Raman is the uncle. Yes. Majnu Ali is no more. And this is the only evidence you have. Any marriage certificate?
School certificate 42 months.
Where is the school certificate?
And after this, my land document has also been.
Mr. Ali, just take a look at the school certificate. Mr. The school certificate, the information contained, if correct, supports the case of the petitioner. Let the petitioner examine the school headmaster along with the school records. Because the Majnu Ali, little variation. Mother's name Jabeda, Gaon Gadhari Rupara, district same Borbeda. So we send it back. It was not able, but the first time is happening. But this is a good substantive material to indicate something. Let him have the opportunity. Let Mr. R. Ali learn counsel for the petition. R. Ali learn counsel for the petition. Also heard sorry by the petitioner Jainab Khatun was referred to the Foreigners Tribunal number 10 Bozali Patsala for rendering an opinion as to whether she is the person who entered the state of Assam subsequent to 25/3/1971. The petitioner relies upon a voters list of 1970 of village Gandharipara, Moza Hauli police station, Borpeta, which contains the name of Majnu Ali, son of Abdul Khalek, at serial 380, and Motiar Rahman, son of Khalek, at serial 381. The petitioner Motiar Rahman, son of Khalek, deposed as DW2 before the tribunal. And stated that the petitioner Jainab Khatun is the daughter of Majnu Ali, son of Abdul Khalek. Stop. In this proceeding, the petitioner also relied upon a school certificate issued by the headmaster of number 61 Gandharipara LP School, which shows that Jainab Khatun is the daughter of Bosnumia, whose mother is Javeda Khatun, being resident of village Gandharipara. The evidentiary value of a school certificate as determined by this court in its judgment dated so and so, that the information contained in the school certificate should be supported by the master through his deposition before the tribunal by producing the original school records, which may contain such information. In view of the above, matter remanded back to the tribunal to allow the petitioner to produce the school certificate issued by the headmaster of number 61 Gandharipara LP School, and also to allow the petitioner to bring in the evidence of the headmaster of the school along with the original school records, which may substantiate the contents of the substantiate the information contained in the school certificate. Petitioner also relies upon a copy of the Jamabandi in respect of village Gandharipara, wherein at serial number 10, the name of the petitioner had been mutated in place of Mazlumia, son of Khaled, with reference to an order dated 7/1/2020 of the circle officer. The petitioner may also produce the order of the circle officer dated 7/1/2020 to rely upon the information that she is the daughter of Mazlumia, son of Abdul Khaled of Gandharipara village. The petitioner to appear before the tribunal so and so. Any reason order passed in favor of petitioner shall prevail of the earlier opinion dated first. Till the reason order passed, no coercive action will be taken. Send back to LCR immediately.
I think three.
Yes. You have done the necessary correction. Page 67. Same incorrect copy or incomplete copy. Fine. The tribunal to forthwith send the complete evidence rendered by Mahamaya Biswas as DW as DW2, including the examination rendered in cross-examination. By an earlier order of 25/1/2023, we required the petitioner to incorporate necessary correction in page 67 to the writ petition so as to provide the identity of the person whose deposition is annexed therein. But in response thereof, the petitioner applied for a fresh certified copy of the deposition available at page 67. But the certified copy provided also does not contain the name of the person who had deposed. Therefore, in view of the above, the tribunal to make available before the court the complete complete so and so. The complete evidence of DW2, including the cross-examination, which may indicate the name of the deponent or name of the witness when deposed. The LCR of FT case number so and so we also call for. But issue notice is it interim order. Sorry. 6 weeks. To complete interim order.
Item 5.
If the complete particulars of the witness deposing as DW2 in cross-examination had not been recorded by the tribunal to also provide a show cause as to why it was not so done. No, this is item number 5. Item 5, there is no last order. This is the first time it is. 4 was adjourned. Yes. Page 26. You have examined the headmaster also. Headmaster was examined. Where is the position of the headmaster? Any other document?
Yes. The deposition of the person Gowra is also present.
Where is the government deposition?
Gowra deposition is on page 16 and direction 16. This is the people.
How old is this computer? His age? And how old is Asaruddin?
Gowra is 43 years old.
And Asaruddin age?
So he was a substitute certificate. He was born May 1987.
87. He was around 40.
There is a
School register.
Register book of the year 1995. In that certificate, exhibit 1 is reported in Asaruddin, yes, the school in 1996. I have reported the name of Asaruddin in the register book 2 years after he left the school. At the time when I found him to the admission in the school, I was not the headmaster of the school. I have issued the certificate to him on the information given by Asaruddin. The contents of the certificate issued by me and the contents in the school register book do not carry. I have not mentioned in my certificate the date of admission in the school. I have not produced my identity card to show.
The director of elementary education Assam, as well as the block elementary education officer Lahori Khan, we included the respondent number. Yes. Anybody from the education department?
On the information provided by the petitioner himself. That is the end of everything. First, let us read documents here presented.
I was also understanding, but the potential is
Party document is already on record.
Several identities.
Loud than this records are indicated. Where the certificate has been procured from this.
We have included the director and block elementary education of Lahori Khan as a respondent. Ask the director to make an inquiry and submit a report on the next returnable date. We are passing our order. Heard Mr. Jehan, Hamman Bank Council for a petition. To substantiate his claim that the petitioner is a citizen of India, reliance is placed on a certificate dated 16/8/2018 issued by the headmaster of of Number 1, Saria Gaon LP School. It is noticed that the said certificate had also been countersigned by the Block Elementary Education Officer Lahorika. In his deposition, the headmaster of the school, Moinul Haq Akhanda, had deposed that the certificate was issued as per the information contained in the school admission register of the year 1995. But the certificate depicts that the petitioner was a student of the school up to the year 1993. In the circumstance, on being cross-examined, the headmaster stated that the information contained in the register book of the year 1995 was recorded after the petitioner Asaruddin had left the school in the year 1993. And further, that when Asaruddin took admission and was a student of the school, the person who deposed as the headmaster was not the headmaster of the school. Thirdly, it is stated that the certificate was issued to the petitioner Asaruddin on the information given by the petitioner. If it is so, the director to make an inquiry on the Block Elementary Education Officer as well as the headmaster of the school as to under what circumstance the said certificate was issued and whether there is any illegality and infirmity in submitting the certificate. List on so and so for the report from the director. A copy of this order be provided to MS and NM Sharma, then counsel for the Education Department. Till the next returnable date, no coercive action be taken against the petition. You protect the petitioner.
22nd March. I think 7.
Only written statement and immediate for the certificate subsequently accepted. And once of the to
What will be the cost of the opportunity? 4%. 4% of how much? Regularly, yes, no, regular. How much cost is the post for going back? 3,000, I believe. 3,000. 3 is the standard. We are giving it to you. How can there be discrimination in favor of the petition, this petitioner? 3,000, go back.
So,
What will you have? Heard Mr. Motin and counsel for the petitioner. The petitioner who was referred to the which foreigners tribunal? Foreigners tribunal number 8, Gwalpara, for rendering an opinion as to whether. Then what is page 82? 82 is written Gwalpara. So what is 82 then? What happens to vacancy? 6 of them, sorry. Rajikali. 20. 25. The petitioner
What referred to the
Rajiv Ali was referred to the Foreigners Tribunal number 4, Dorong Momodoi, for rendering an opinion as to whether he is a person who entered the state of Assam from the specified territory subsequent to 25/3/1971. The petitioner received the notice from the tribunal, initially appeared, filed written statement as well as some evidence of some of the witnesses, but thereafter, without any acceptable reason, remained absent and did not take further part in the proceeding. In the aforesaid circumstance, the ex parte order dated 27/10/2021 in FT case 385/2012 was passed, resulting in registration. No acceptable explanation is given by the petitioner for remaining absent in the proceeding before the tribunal. From such point of view, we do not notice any infirmity in the order dated 27/10/2021. But at the same time, the petitioner makes a prayer that he be given another opportunity to present his case before the tribunal. In the circumstance, the prayer of the petitioner is accepted. But however, on a payment of cost of ₹3,000 to the District Legal Services Authority, Dorong, the petitioner to appear before the tribunal on so and so, after showing the necessary proof of the cost having been paid, as the matter is remanded back, the ex parte order dated 27/10/2021 in FTS is recorded.
first appearance in 2019, and after that, kept on taking adjournments when the COVID state budget. But now, regularly at year end, this budget. 19 to 26% already gone down.
And which provision of law should have passed their law? No, under which provision of law? No, under which provision of law should have passed an order? 226 does not prevent it. It's a future event. If he does, he'll face the consequence. But how can you guide somebody in future?
Another 5 years go by.
Sorry.
That's a 5 years go by.
Sorry.
Another 5 years go by.
And upon appearance, the tribunal to decide the matter within a period of 3 months, without giving any further and the petitioner to also cooperate in the proceeding.
Item 8.
It's part of it. That is, only one.
Same order, madam. Yeah, what to do the same for each video, tribunal change.
Item 9.
Only the tribunal number will be changed and the name of the matter. Oh, it's very important details. Yes. Page number. Five videos. Who is the father? Wazuddin is the father. Insan Rabi is the grandfather. And the petitioner is Raijan Begum. Which document will link up husband and Raijan? From where the Gangura came to know about all these? No. Gangura can give evidence either from his own knowledge or on the basis of some public record. Public record. Which public record? Page number 60.
Statement. Down below. The name of the father of woman is recorded in the voter list of 1970 and the issue number.
How does he know that the man of 1970 is the father? What is the source of his knowledge?
Most of the knowledge is obvious in the cover and the statement of the village.
Gangura doesn't, it's not that Gangura knows everything in this world. And what is evidence and what is certificate? Certificate is a document by which one person states the existence of a particular fact. The person either knows that fact from his own knowledge or from some public record. Otherwise, it's a creation of fact. So you have to show us from what is the source of the knowledge of the Gangura.
I don't have to ask you. We have to take 59 minutes. We have to take 60 and I'm able to look into it.
Give a complete the petitioner to provide a complete copy of the petition to the legal counsel for the home department, the government of Assam. The petitioner to also file an affidavit stating as to what is the source of the knowledge of the Gangura Sri Hiban Vaishya, who had issued the certificate at page 60, annexure 13, small capital brackets, small a. Similarly, the petitioner, the Panchayat and Rural Development Department of the Government of Assam to be also implemented as a respondent of pursuant to the petition. To the secretary, anybody from Panchayat? The secretary to the Panchayat and Rural Department to make an inquiry as to on what basis the Gaon Panchayat Secretary Mahadev Das of number 35 Uttar Bedkari Gaon Panchayat had issued the certificate available at page 39 and 30 to the petition. It is noticed that the certificate contains a serial number and it is in a printed form. The secretary of the Panchayat and Rural Development to also inform the court as to what is the basis of the Gaon Panchayat secretary issuing such a certificate. List on so and so for the affidavit of the petitioner stating the source of information of the Gangura as well as the report of the Secretary Panchayat and Rural Development Department. It is noticed that the affidavit certificate as page 39 had also been countersigned by the 59 had also been countersigned by the circle officer, stroke executive magistrate, stroke block development officer. An inquiry be made as to who had countersigned and why the state official had countersigned it. List on so and so. Till the next returnable date, no coercive action be taken against the petition. A copy of the order. So I have seen the Mr. Dotto, you appear for PNL. Will give a copy of this order. We have asked the secretary of the department to make an inquiry as to on what basis the Gaon Panchayat secretary is issuing this certificate and who had countersigned it. Some circle officer or somebody had countersigned it also. And the basis of the knowledge of the regarding the contents of the certificate, whether it is record or it is some personal knowledge or it is. And secondly, these certificates are given in a fixed printed format. Is it the custom of the, or it is the prevailing practice in the department? Item 10, a copy of the order be provided Mr. Algo. Yes, Mr. Ishaq.
And the operating matter of the Petitioner would not matter the linkage of the Indian bank, as well as matter the she could not establish that her parents
Petitioner, who is the father of the petitioner?
grandfather of the petitioner, my lord, after
Page number.
and see my address, my lord.
No, your page number. And, where does the name of the father of the petitioner appear? Any voters list, any 66 page number?
Page 73.
73.
Sorry, page grandfather, page.
Okay, let us see the grandfather, page 70.
Page
73.
73.
73, Namsher Ali Sheikh, village, ward number 1, Goripur. Okay, and who is the father?
Other is my lord, page my lord, the list of 1977. Page my lord, 77.
Sorry,
Page 77. Operating,
77.
operating fund is page 78.
This is of ward number 1, Goripur, 1977.
Right.
Abdul
Abdul Samad.
Samad or Kader, who is the father? Abdul Samad is the father. Which document will show that Abdul Samad is the father of this
My lord, exhibit 1, my lord, page my lord,
page number?
page 67. So I can get.
Have you examined the headmistress? Was the headmaster of the school examined?
Yes.
Which page?
My lord, I see my lord, page 90. It will be.
Yes, Madam Verma. We declared it today here itself, or we send it back. This is too overwhelming a material in favor. Grandfather, The name of the father appears with the grandfather. Same village all the time. Town, in fact, Goripur town. School is also Goripur town. School certificate is there. Headmistress comes with the school record. All the requirements of law is met in this case. Sorry. No, I brought the attendance register, counterfoil exhibit, everything. She had brought the school records. 90 or today I have not found the admission register. Still there is no application. I brought the attendance register. Doesn't matter. We are not, no, we are, the question before the court is not whether the person has passed the examination or not passed the examination. We require this affidavit only for the information contained therein regarding the identity of the person. That is there. It doesn't matter whether it is a pass certificate or it is a transfer certificate. But that is not the issue before the court. So I think we can declare this person also. Remand or declare is today itself. We can also declare because we can easily observe that the burden under 9 had been already been discharged. Doesn't matter. See, every matter doesn't mean that it has to be dealt in the same way. Some matter we may dismiss, some matter we may allow empty, some matter call for the record, some we may call for some more information. But this is too overwhelming material in favor of the petitioner. Why trouble the petitioner further? It is noticed that the petitioner relied upon the voters list of 1966 of village ward number 1 Goripur, containing the name of Namsir Ali Sheikh, son of Janu Sheikh, at serial 132. Petitioner also relies upon the voters list of 1977 of ward number 1 Goripur, which contains the name of Namsir Ali, son of Janu, at serial 160, and Abdul Samad, son of Namsir at serial 162. Petitioner claims that Abdul Samad of serial 162 of voters list of 1977 of ward number 1 Goripur is our father. The petitioner refers to a school certificate issued by the headmistress 2402 number Aman Memorial LP School, Goripur, which contains the information that Hamida Khatun is the daughter of Abdul Samad and Anwara Bibi of ward number 1 Goripur. The headmistress of the school had also been examined and had deposed in favor of the contents of the certificate on the basis of the school records. Prima facie, it appears that there are overwhelming materials in favor of the petitioner that she has discharged her burden under Section 9 of the Foreigners Act 1946. MSA Burman and Honduras seeks for adjournment to examine the materials on record as indicated above. As prayed for, list on so till the next no coercive action be taken against the petitioner. Maybe, yes. Okay, the headmaster changed in the meantime. An issue had been raised that a certificate was issued by one headmaster, where it is the deposition was made by another headmaster. But Mr. M. Islam, like the petitioner, explains the situation by stating that the earlier headmaster who was holding the office had issued the certificate, but in the meantime, there is a change in the headmaster of the school, and therefore the incumbent headmaster had deposed on the basis of the school reports.
Number one, just confirm the date. Consolidated everything. Certificate that is not showing. The one who gave the proposed one.
31. Naturally, new headmaster, young, no school record, legal record. Had it been Gambura, we'd have taken it more. But headmaster can always depose on the basis of school records. Next day, any. Your exam. 20 March. No coercive action of any kind till the next week. Any kind of before.
Item 11.
Yes, Mr. Mukherjee. Page 37. Type copy of what?
Page 38. Entries issued in the name of the grandfather of the
What slip?
entries.
Entries. Page number 30.
37 is the type.
36 is the photocopy. 37 is the type copy. 30 is.
Here's the name of the grandfather, Hare Krishna Das. Also the name of the father and serial number is included there. Recorded.
Okay. And the petitioner is Deepa Das. Which document will show that she is the daughter of Yogesh Das?
Documents are mentioned. One at page 45 to 46. Certificate. And another is an admit card issued by the HSS. Seva. One is at page 46, another is at page 48. These are issued by the Board of Secretary. Is there executed? And
But the villages are different. Village is different. The school certificate is a village Tapatoli. And the entry certificate records he is the resident of by Politola, West Bengal. Any material to explain?
so there is a statement that after entry into India, the family shifted to Tribunal. And the petitioner was also born in Tribunal. Regarding the validity of this document,
No. If the petitioner is the daughter of Yogesh Das of the entry certificate, then you have proved your case. But you have proved that you are the daughter of Yogesh Das of another village. So you have to bring in more material to show that the two Yogesh Das, they are the one and the same person.
for that, the document of the mother of the ration card and in which the mother was the wife of Yogesh Das.
So how does it work?
That person.
No. Your mother is the wife of Yogesh Das, no doubt. But the Yogesh Das of the entry certificate and the Yogesh Das of this village Sapatali, whether they are the same person or not. They may bear the same name, but whether it is the same person, do we have any material to indicate that?
Statement. And the age also. possible.
Beyond the statement, nothing else. Do you have any other material?
Evidence also.
No, do you have any other material?
Other material, the executed document will be
Mr. Mukherjee. Just ask Madam question. And explore after discussing whether there is the possibility of bringing in any further material. If we have, we allow you to bring in. Because otherwise you'll have to establish that although the two names are same, that it's also the same person. Think of any material. You use your legal equivalent and think of what possible materials what materials will be possible to bring.
In this regard, there is another exhibition of the brother of this exhibition. He was also declared to be and that is also.
But that is pending. Then again, another problem will be there that he is the brother reader to prove that also. There's a difference between making a statement, making a claim, and producing at least one material to show to substantiate that claim. When you are next week. This next week on the prayer of Mr. B. J. Mukherjee, the counsel for the petitioner. The learned counsel in the meantime may explore as to whether any material is available to show that Yogesh Das of the entry certificate at page 28 and the Yogesh Das referred in the school certificate at page so and so are one and the same person. Yes, Mr. Rashid. Sorry. Which page? Kadoli Khatun, wife of Yada.
And the other serial number of University 51.
It is Hugu Doba. Now, who is referred? Who is referred?
I believe.
No. Who is referred? Kadoli Khatun, wife of Yad Ali of Huguri Doba village is referred, or somebody else is referred? Where is the reference for that? This is a difficulty. This is Kadoli Khatun of Borpahar village.
They shifted to Urva. And now again they have come to their original husband's place. That is not
How do you prove all this?
that is I have a
Any material to show all this shifting? Something has to be there. But orally, how? No, orally, anybody can claim anything, whatever. Show us one material, which may indicate that the person from Gugudoba had actually shifted to Borpahar. Burma, timing, let us pass an interim order. Possibly it is yes, but that material has to be produced. That so and so wife of Yadali of Hudova and the same person, wife of Yadali of Borpahar, they are same person. It's subject to that. You have to bring it forward. Mr. Eros. Notice 6 weeks, history of history days. Call for the report of application number 8076 G/16 from the Forest Revenue of Borpahar. The petitioner is required to produce some further material which may indicate that Kazoli Khato, wife of Yad Ali of village Gudova, whose names appeared in the voters list of 1970 of village Gudova, and Kazoli Khatun, wife of Yad Ali of village Borpahar, are one and the same person. I will begin. Also, Mr. Singh.
Professor, yes. But I'm also wishing you a lot of advice that very report. Reported that I'm the son of Muslim. So now I'm established that Muslim is my father and Buddha is your worship since this is Buddha.
So, no, Mr. Singh, you are referred as son of Moksed Ali of village, whatever it is,
Yes,
and you have proved that you are son of Moksed of that village. So now what is the difficulty? So now what is the difficulty? They did not accept this material.
That is not accepted and sound the initial regarding the 66 here.
No, forget about all those. So now please show us where is the order of reference? Where is the reference order?
Is from and your lordship.
Just a minute. Where is the reference order? Reference order. Page 23 is some voters list.
Number 80
83.
is reference.
Hmm.
Order
Just a minute. The reference is student opinions to better proceed Bilal Hussain, son of Moksel of village number 4, Hasila Bill. Whatever is a foreigner. Hasila Bill. Now, you have referred to voters list of 1966 of village. Of which village? Which page, Mr. Sheikh? The page number.
Yes, number 23, my lord, 1970.
1970 voters list, page 23. Yes.
That case.
No, village Batawari. And the person referred is Bilal Hussain of Hasila Bill, ward number 13. Okay, 1970 Kalu Sheikh. Where is the name of Boxet? Linked with Kalu.
Kalu in Bhutan is 1966, my lord.
I see. Where is
My grandfather was 21.
Mr. Sheikh, we understand everything. Where is the document to show Boxet and Kalu together?
Oxygen and Kalu.
Your Lordship. Your Lordship, please to come to this hearing.
Page number 30. This is Mokse, son of Kalu, village Batavari. It's okay. And now, but Bilal is of village Hasida Bill.
Because I shifted.
What is the material to show your shifting?
The temporarily I have here. That is
Understand.
why
Over and above your statement, what material you have?
accept this particular document.
Then how only statement is not sufficient?
These were only corporate received from one place to another.
Mr. Sheikh, you know the requirements of law. Statement is to only to make a statement. That has to be substantiated with material.
That I have stated in my written statement.
So tomorrow in a 302 trial, anybody who will make a statement, no, I have not committed the murder. Is it good enough?
But my own submission before the Lordship.
Sorry.
Shifting from one place to another place. It is not a necessity that some documents should be there that I have shifted. Any place I can leave. With the territory of.
Should I record your submission and pass the order? Should I record the submission and pass the order? You say yes, we can do it. We'll record your submission. That's for shifting. There is no necessity to produce anything. Should I record that submission?
My submission is this.
Mr.
Today I have coordinate.
Very well. The petitioner refers to the voters list of 1966 of village Batavari, which contains the name of Kalu Sheikh at serial number 63. Petitioner also refers to the voters list of
Madam, may I claim one thing, madam? Sir, on this point, madam, let me answer. Let me prepare for what.
adjourned on the prayer of Mr.
Madam,
Council for that.
let me prepare.
Next week.
I can answer your lordship.
List after a week. On the question as to whether any material is required to show that there is a shifting of the proceeding from one place to another, or merely a statement will be good enough under the law. Article 14. Mr. Sheikh, just a minute. Instead of raising this, why don't you take an interim order today? But this question will remain open that you have not produced any material. You have to bring any further material that you have.
That will not be. That will not be.
You don't want. Okay.
Let me.
Very good. Very good. As you wish. Who is this person? Sahabuddin. Who is the father of Sahabuddin? Who is the father of Sahabuddin? Where does his name appear? Mr. Bhuvan, at which page is the voters list of 1971? It is not annexed. Mr. R. Bhuvan, Land Council for the petitioner seeks for adjournment to bring on record the voters list of 1971, which the petitioner claims to contain the name of his father. Article 15. Azimuddin Sheikh, I don't know if father. And Ainal Sheikh and Azimuddin. Page number 50.
1997.
This is another village. Before this PW3. Where is it? 74. Okay, Mr. Pike, Interlocutory. Then Mr. A.W. The petitioner relies upon the voters list of 1966 of village Rampara Nongke, which contains the name of Azimuddin Sheikh and serial 133. The petitioner also relies upon a school certificate issued by the headmaster of Rampara High School, which provides the information that the petitioner is the son of late Muhammad Azimuddin of village Rampara Kothar. To that extent, the headmaster of the school had also been examined, who deposed on the basis of the records produced before the tribunal that the information contained in the certificate is as per the school records. Issue for this written considering the prime facie case made of interpreting records. 116. Page number. Page number. Yes, and Juramali and Nosese. Any document which shows Nosef Sheikh and Juramali together. 51. What is 51? 41. What is it?
is the voter list 1970. 41. Is the name of my father, Sobedali, and mother.
This is just a minute, 1970. 1970 village, Kopatoli Kalpani. Earlier one was voluntary. Okay, fine. Kopatani. Javed Ali and mother is Majiron Nessa. No, your wife of Javed Ali. Who is Javed Ali? Huh? Your father is Javed Ali. Okay, now where is the document to show Juram Ali and Javed Ali together?
Yes. Page 42. Serial number 154.
This is Javed Ali we have seen. Mr. Rashid, we are aware of it. Where is the link between Juram Ali and Javed Ali?
Serial number 146.
So finally, asking everyone. No. Forget about that Noser Sikh of the other village. Mr. Kaim, come to page 40. This is voters 70, village Kopatoli. Kopatoli Kalpani. It has the name of Javed Ali. Okay. Now come to page 46. Not 46. You come to page 42. Kalpani, huh? Kalpani. So are there two different villages? No, it's same because you see Moza Bagbor. Page 42 is also Moza Bagbor. And this has the name of Javed Ali and Juram Ali together. So this is good enough. When Javed Ali, his name is in 1970, village Kalpani. Juram Ali is also in the same village along with Javed in 77. And what material you have?
77 was not executed before.
No, now it is before us.
They are making it with a person. It was not other.
Understand, but these two documents together indicate something.
And we might not have certain distance, but it was not there. Then the court committee might have indicated that.
Okay. The petitioner referred to the voters list of 1970 of village Kopatoli Kalpani, Moza Bagbor, which contains the name of Javed Ali, son of Nosir Sheikh at serial 375. As well as the voters list of 1977 of village Kalpani, PS Bagbor, which contains the name of Javed Ali, son of Nasir at serial 144, and Juram Ali, son of Javed at serial 146. Consider privacy case made of that. We have noticed it.
Yes. You take an opportunity to certify.
No, we have noticed that. But yes.
Now, is how things are coming.
Record call.
Other name is recorded in the voter sheet of just 1963, page number 33.
Just
Others name is on page number 36, 1966 voter list.
36. Kalimuddin. What is A? Abdul. And petitioner is Muhammad Sultan. Sultan.
Page number 44.
44.
Is voter list not also accepted for the latter time.
It's okay if I have it, we take to
Why not? Same village.
Baki activity more refers to the voter list of 66 of within Hati Dua, Moza Hatisu, country Nemo, E. Kalimuddin, serial 170, and also the voters list of 1997 of village Hatizwa, containing the name of Kalimuddin, son of Nabi Hussain, and Sultan, son of Kalimuddin, at serial 633 and 635. Considering the above, private investigation and again on alternate responsibilities of the internet. 18. Samshuddin Sheikh.
Yes, sir. Other thing is there is a voter list of 66, 70 and subsequent voter list. Page number 50 is the voter list of 1966. And page number 80.
Page number 80.
Page number 15 option. 66 voters there.
Monia Sheikh.
For the shape.
Father Sheikh.
Yes.
Son of Hassan Sheikh.
Then page 7.
Village. What is the village?
Village is Keramari.
Gaonampur.
Keramari,
Kemari.
70.
And Samshuddin and the father together.
Yes, together in 1997, page 20.
Page 23.
In 1997, he marked as these options. In
They didn't mark here B, but this is village. Koimari. Father Sheikh. The name of the petitioner Samshuddin.
Serial number 550.
The petitioner refers to the voters list of 1966 of this Koimari Part 4. Under what was the police station? Under Golabganj police station, which contains the name of Father Sheikh, son of Hassan Sheikh, at serial 335. Petitioner also refers to the voters list of 1997 of village Koimari, which contains the name of Father Sheikh, Father Sheikh, son of Hassan Sheikh, at serial 513, and that of Samsudin Sheikh, son of Father Ali at serial 522. And both of them are indicated to be of the same household. By investigating. The petitioner to also produce the continuous voters list from 1970 up to 1977 of village so up to 1977. Interim and corpus.
In 1970, petition of name is brother's name of other's name is
Page number?
70.
Page number 19.
Yes, page number 42. And my lord, in this case, what happened? My lord, earlier,
No.
the friend of the honorable tribunal, passed by the court by lord 364, and we have to look.
Mr. Talukdar, Mr. Talukdar, go issue by issue. Go issue by issue. Don't mix up everything. It's very difficult to understand. If you are relying on 60 voters list, complete this argument first. Now, who is this petitioner is Amir Ali.
Yes.
Which document will link up Guru Ali of 66 and Amir Ali?
My lord, 66 voter list is there. Guru Ali is his father. 70 voter list is there. Guru is his father. My lord, the husband is there. My lord, page 64. Tribunal judgment is there. Page 64 and here you look. If the judgment earlier is what are the same tribunal as the judgment, taking that is Amir Ali is a citizen of India. Then at the same time, same judgment subsequently in 2016 the judgment was passed. In 2018, another reference was made. In 2018, the same tribunal passed the judgment stating that Amir Ali is a citizen. Page 67 actually. Thereafter, in 2022, the same tribunal, passed the judgment and the Amir Ali is not a citizen of India. 71. So then he projected for the what projected for the one to be which is very painful. So my lord, it earlier two judgment has stated that Amir Ali is a citizen of India. My lord, and we have looked page 64 and my lord, page 69. There are two judgments of the same judgment. Passed the judgment, saying that Amir Ali is a citizen of India. And now in the same tribunal, my lord, again, in 2022, hold the view that hold the view change then after 25 to 71, thereafter declared for him.
Yes.
After 25 years, for him. Now, my lord, can we have a look of this document? My lord, Jawabari to be page 63, my lord. Jawabari to be, my lord. He, Kurubati, Amir, I would be. They are naming the 1970, 71. Their name of the pages that other things. I have already annexed. And it is what I think the court was also annexed. And the agreement.
Now he has proved before the tribunal, and we have two occasions that he is, yeah, subsequently in the third, but the third is a tribunal holds that he not received. Now again, this does that only one is protected, otherwise, what we say, and he has to do protected one. Whereas page 73, in view of the shortcomings of experience to solve against the evidence, the second Tribunal and the district to monitor what are fair and legal will be to start and cover it too. Therefore, I was declared to back it, therefore I could think as a foreigner. And if I consider opinion, the contest to go to after this illegal migrant has been entered to India and after 25 years.
Want to submit something more?
I don't need to, I have submitted
Petitioner to formulate the submission issue wise. In this next. This next.
I don't have this is.
This next thing. Or today itself, we first you formulate issue wise, we hear. Everything mixed up, we don't understand anything. We have not understood whether you are taking the ground of res judicata or you are taking into ground that the materials are available to prove your citizen. We have not understood it. So you formulate your submissions, issue wise, make your submission. Whether you want to do it today or some other day. Just next week, just next item. I think 20. Next. First, take your call whether you want to rely on res judicata or you want to rely on that there is a material to prove your citizen. Next item. Yes. Page number 27. Page number 27, grandfather. This part 1. Who is the grandfather? Bokatullah. Kosu. Kosu Sheikh grandfather. Okay. Now who is the father? Page 35. Just a minute. Who is the father? Secondarily. Okay. Now, Abdul Hamid. Any document to show Secondarily and Abdul Hamid together? Petitioner is Hyderabad. Abdul Hamid. Yes, Mr. Pai. Enter. Your name, please. JP Kosari, the number of petition. Petitioner refers to the voters list of 1966 of village 214 Erhani Part 1 in the Dhubri district, which contains the name of Kosu Sheikh, son of Bakatullah, at serial 29. Petitioner also refers to the voters list of 1985 of village Erhani Part 1, which contains the name of Kosu Sheikh, son of Bakatullah, at serial 54, and Sekandar Ali, son of Kosu, at serial 55. Petitioner further refers to the voters list of 216 Erhani Part 1 of the year 2005, which 2000 10, which contains a name of Secondar Ali, son of Kosu Sheikh at serial 852, and Abdul Hamid, the petitioner, son of Secondar Ali at serial 855. Considering the primary case matter of PDD, interim PDD1. Taking all for the records, is not so and so.
Item 21.
But Samir on this side. Will the father of Amir on this side? 21. Toimuddin. 66. Here. Any document to show that Amir on this side is the daughter? Mother, where is the evidence of the mother?
It's
7. Page 67. Mr. Fine, what is one disturbing aspect? This examination in chief is given in the form of affidavit. When you cross-examine, the tribunal does not record the name of the deponent, of the witness deposing. Straight away, I am. Who is this I am? How we have to infer that this I am is Surya Bhanu Nesa? That it has to be recorded. Why we are doing it in this manner? This is the second or third matter I came across in course of the day. Suppose it had been oral evidence, initially you write the name, thereafter continuously you write cross, then the necessity to write the name of the witness may not be there. But when it is separately made, there has to be some record who has made this statement. Even we call for the one of the original ones. Original one is also like that. Then no one is bothered to write. Somebody has to train up these members how to take note of evidence.
I'll take it for that. I'll take it for that.
This is not the isolated case. Quite frequently we are noticing this. So we give it the advantage. Call for the record side. Sorry.
Resolution item 22.
And the cross we read just now in the English version translated type copy, you wrote synopsis. Synopsis is the original content or it is your version? Original content. How can there be a synopsis of a deposition? This is while typing out, you put it on your own, or it, in an original document, it is like that. It's like that only. It's written synopsis. That key tribunal number given. The tribunal to explain as to under what circumstances page number so and so to deliver. Cross-examination is stated to be a synopsis of the cross-examination rather than it being the deposition. Ask the tribunal member What does he mean by synopsis? There is either deposition or there is no deposition. Synopsis means a third person will put his own version of the evidence. This next item, item 22.
Item 22.
And John on the prayer of Mr. A. Moti, land counsel for the petitioner to do the needful as indicated in the order of 16/2023. Perhaps there is no material.
Item 23.
When the matter was called for hearing on 17/2/2023, none appeared. And an order was passed that if on the subsequent call none appears, adverse order shall follow. Today again, when the matter is called, none appears. But however, in the interest of justice to the litigant, instead of dismissing the matter for default, we propose to appoint an amicus to take up the matter on behalf of the petitioner. Agree? MSD Ghosh, land counsel for the petitioner, is appointed the amicus, the registry to provide the copy of the petition, etc. to the land counsel. Just after 1 week. 2 weeks, just after 2 weeks.
Item 24.
Yes, item 24. A John on the prayer of Mr. G. Sharma to enable the to obtain a copy of the petition from the petitioner. Mr. Gaswati. Field number. Field 40. 14. Kutimia is the father. 66 village, Sangmaji Mitir Kothar. And what document to show that Kulsuma Begum is his daughter?
Page 9 is the certificate.
Page 9. Have you examined the headmaster? Go back and examine. And Mr. G. Udil, land counsel for the petitioner. Also, so the petitioner, Kulsum, Musamad Kulsum Begum, had been referred to the Foreigners Tribunal number. Foreigners Tribunal number 10, Nogao. The Foreigners number 10, Nogao at Sonkordev Nagar, Hosai, for rendering an opinion as to whether she is a person who had entered the state of Assam from the specified territory subsequent to 25/3/1971, resulting in registration of FT bracket D case number 88/2015. The petitioner relied upon a voters list of 1966 of village Changmaji Mikir Kothar, T.S. Jogonamok, Moja Jogonamok in the district Nogao, which contains the name of Kutimia, son of Muhammad Ali, at serial 111. The petitioner claims that Kutimia, son of Muhammad Ali, of the voters list of 1966 of Sangmaji Mikir Kothar village is her father. To substantiate, the petitioner refers to the transfer certificate issued by the headmaster / secretary of Sangmaji ME School, which contains the information that Kulsuma Begum is the daughter of late Kutimia and Toslima Begum of village Sangmaji Mikir Kothar. But however, as the headmaster of the school had not been examined from and as required under the law as rendered in Onimadas, Onimadas, so and so. The petition, the matter is remanded back to the tribunal to enable the petitioner to examine the headmaster of Sangmaji MU school along with the school records to establish the establish the information contained in the transfer certificate, which is annexure on page 9 to the petition. Petitioner to appear before so and so. Upon the examination of the headmaster, the tribunal may pass a reasoned order, and in the event a reasoned order is in favor of petitioner shall prevail over the earlier opinion dated so and so. And if against, consequences under the law would be applicable. Appeared in unity. No coercive action against the petitioner till the reasoned order is passed. Send back the LCR. Petitioner may also be allowed to produce any further material so advised.
Item 25.
Sakina Khatun, yes. Who is the father of Sakina Khatun? Page number. 15. Billah Ali Sheikh. Son of Kalu. With the petitioner, Sakina. Which document do you show? Sakina is the daughter of Billah Ali Sheikh. What is the basis of that certificate? What is the source of knowledge of the secretary? How does he know? We accept the certificate, but we also want to know what is the source of knowledge of this secretary, how he knows all these facts. Either he has personal knowledge or he is certifying on the basis of some public record. Which one? Personal knowledge. How does the secretary have personal knowledge? Sorry. No, it may not be, but how does the Gaon Panchayat secretary have a personal knowledge about the existence of this fact? Headmaster, which page? Same certificate by headmaster and secretary both. Where is the certificate? Page number 16 is some hotel list. Who is certified? यार द्वारा प्रमाण पत्र दिया जाए जे सुकीना बेगम उल्लेखित उत्तर विलासदारी यूनिवर्सिटी who had given this? Headmaster. Countersigned by headmaster secretary. The headmaster of what high school? Kalabari High School, and the secretary of what Gaon Panchayat? Kalonga Gaon Panchayat to find the respective affidavits stating the source of the knowledge as to why they had certified that the petitioner Sukina Begum is the daughter of Bilal Ali Sheikh. From where they came to know this. If he is a genuine one, we'll accept it. Just after. And how will the headmaster and the secretary know about it? A copy of the order be made available to Mr. J. Pine, when comes to Home Department, who shall do the needful to inform the headmaster and about the requirement of the certificate. Of the requirement of the affidavit.
I think 26.
Only Chamia. Yes, will the father. Will the father.
Total is 1966.
66. Which page? 60. 16 or 16. Who is the father? Rahmat Ali, son of foreign.
Village Arbalita.
Village
Arbalita. Arbalita.
Abrar Vita. Okay. Now, which document will show that Malik Khan is the son of Rahmat Ali?
Yes. 1997, totally page 23.
Page 23. Son of?
Serial number.
No, son of Rahmat Ali.
Mother name is Rabia.
Just a minute. Abrar Vita. And who is the mother?
Rabia.
Rabia Khatun is the mother.
And
Yes, Mr. Fine. Go back. And you produce all the intervening voters list from the 66 to 97. Because you see, Rahmat Ali, serial 189, Rabia Khatun, serial 189. Rahmat Ali 88, Rabia Khatun 189. Village is Abrar Vita. Again, Abrar Vita, 297 is Malik Khan, son of Rahmat, all these things happen. And 298, Rabia Khatun, wife of Rahman. Village is same. So if you have the in-between voters list, maybe you can find out more details. You produce everything before you try. Admit card. Admit card does not indicate the village.
yes.
So this can be son of Rahmat Ali of any other place. The school certificate is better than admit card. So if we have a SEBA admit card, you must have studied in school. Why don't you produce the school records? Everything is there. Why don't you produce it? Why don't you produce it? For HSLC certificate, give the name of the village. Contains the name of the village. Where is your HSLC certificate? Did not pass. It will be on the heard the study motive and concept for the petition. Also, the petitioner Chanmia has been referred to the foreigner's tribunal number. Yes, Mr. Moti, instead of talking, why don't you help us? Foreigner's tribunal number? Number 4, Gwalpara. For rendering opinion, the same line, resulting in registration of case number G41085/2016. The petitioner relies upon a voters list of 1966 of village 305 Abrar Vita, PS Lokhipur, in the Gwalpara district, which contains the name of Rahmat Ali, son of Foreign, at serial 188, and that of Rabia Khatun, wife of Rahmat Ali, at serial 189. Petitioner also relies upon a voters list of village Abrar Vita of the year 1997, which contains the name of the petitioner of Malik Khan, son of Rahmat Ali, at serial 297, and Rabia Khatun, wife of Rahmat Ali, at serial 298. It is stated that the name Rahmat Ali referred in the list of 1997 is a misspelling, and actually it ought to have been Rahmat Ali. The petitioner also refers to an admit card issued by the SEBA, which contains the information that Malik Chan Mia is the son of Rahmat Ali. But the admit card does not contain the name of the village of Rahmat Ali. To substantiate his claim further, the petitioner may produce any further school certificate corresponding to the admit card of the SEBA, along with evidence from the headmaster of the school, and the evidence of the headmaster of school, along with the school records, which may establish the content that the petitioner Malik Chan is the son of Rahmat Ali of village Abrar Hita. The petitioner to also produce all the intervening voters list of village Abrar Hita between 1966 and 1997, so as to establish the continuity of the names contained therein. For the purpose, matter remanded back to the tribunal, as indicated above. For the purpose, as indicated above, matter remanded back to the tribunal. It should not be appear on so and so. Any order within for the person. No coercive action. Send back to this.
Item 28.
Just 28. Parents are
At page 27.
page 27. Sophia Begum. Other is page 27.
Page 28.
28.
Other name Ilan and mother
Just a minute. Village is Al Haji, older word better. 66. Bilania is the father and Asatan is a mother. Any document to show?
Another reallocation document.
Page number 68.
All the brothers, along with the brothers and sisters, along with the custody, it's what related in place of the father.
It is different village.
Father. Immediately when I create,
What is the evidence of shifting?
in para 8 of the governance stated that every part of the country is stated.
It's a pleading. Pleading has to be established. Please show some material to substantiate shifting.
Kindly have a look at Malad at page 32. The total list of 1989. Palaji. Here, mother is here.
Of a village, Palhasi, same village.
Yes.
89.
89. Mother, they Asatan Nessa is here.
Just a minute.
In page of
Page number
30.
31.
Other mother sitting is here.
Asatan Nesa's wife of Bilal Mia. And who is the petitioner?
Petitioner, Malad, is married.
Samia Begum.
And younger brother, Gazimur Rahman, is here, Malad. In 1997, other than younger brothers,
Page number.
he is 33, 11 person and 44. The younger brother, Gazi and the mother, Asatan Nessa, they repeated Goramari, they are neighboring Goramari. And elder brother, Siddiq Ali.
The petitioner may explore as to what further material may be available which may establish that the mother of the petitioner, Asatan Nessa, along with Gazibur Rahman, whose name earlier appeared in the voters list of 1989 of village Palhadi, had shifted to the village Garamarigaon of Garamarigaon. Just after a week.
I have one. Doing that together is in the same. That is at this same.
No, that may be. No. That is understandable. But some material to show that these people from Goremari and those people from Palhati, they are the same person.
I have to put in the total list of.
You can try. That is not a bad.
Entire.
Balaji addresses Goremari,
Yes. Up and down.
including the upline and downline voters list of village Palhati and Goremari. After 1 week or 2 weeks, just after 2 weeks.
29.
Here in this case, my lord,
Mariam Nessa, who is the father?
my lord, 60 total list
Page number.
with, that is, 43. 43, my lord, other parents now appeared, paternal and here and grandmother,
Who is the petitioner? Mariam Nessa.
William. And.
And who is the father?
That, total list of 1970.
No, you refer to page 43.
43 is my lord, the total list, showing grandmother's age and paternal age. Arman Khatun is the paternal grandmother. Kusim is the grandfather. And Gula Pramanik and Manik Pramanik are the paternal.
Now, who is page 45?
45, my lord, here, my lord, paternal grandmother is here.
Paternal grandmother. That means mother's mother.
Yes.
Who is the mother's mother? Arman Khatun.
Arman. And father is Kasim.
Mother is?
Customary at 116. And other.
No. Mother's mother and
Father's mother. Other
father's mother. Stated. Otherwise, how can mother's mother and father remain in the same?
paternal.
Paternal. Okay. So Qasim Ali. So Qasim Ali is the father.
Father.
Now, what document will show that Mariam Nessa is the daughter of Qasim?
And here, under the legal document was published to the tribunal in the Kabra certificate. That was also not true.
Do you have any material?
And,
The petitioner may explore as to whether any material is available which may establish that the petitioner Mariam Nessa is the daughter of Qasim Ali, son of Qasim, whose name appears in the voters list of 1970 of village Domdoma. List after 2 weeks. Mr. Sridhar, speak a little more in detail with these people. When you talk with them, maybe they have some material somewhere. If they'll bring it before us. Because sometimes what happens, if you use your acumen and talk with them, maybe they'll think about some material that is available with them. Which one?
On that certificate.
Item 29. But Panchayat certificate, otherwise it is acceptable, but
Was also referred to proof, my lord. It's 72.
very well.
That can be.
But again, but Panchayat certificates, then again a question arises, what is the source of knowledge of that man?
Yes, ma'am.
Suppose the secretary says that I am a neighbor of this family. I know that so-and-so is the daughter or son of so-and-so. That is a good evidence. But otherwise, if out of nowhere the secretary comes and says, so-and-so is the son of so-and-so, we definitely will ask the question, what is the source of the knowledge of saying so? After 2 weeks.
Item 30,
This will appear. Same ARD. Before it is there. Maybe just same person. No, one ARD is undergoing some kidney treatment. Is it the same ARD or different ARD? Same. Then appears for a petitioner adjourned to be discussed. And I felt like what is supposed to be the same person.
31,
Boromon will be funded. Page number.
Page number 19 and 20.
Page number
19.
19. It is possibly very. Dhirendra Brahman is the father. Husband's name. No, husband. Just a minute. Mr. Pine. This is the voter list of 1970. And the Nirovala Burman is also there. So we can declare that this person is wrongly referred to. Her own name is there. You don't have to establish any link or anything else. And where is the order of reference? Page number. Page 41. Wife of Dhirendra. Yes, this person is same person is referred. Your name? You Nanda. You Nanda again. The petitioner Nirola Bala Burman, wife of Dhirendra of village Pastibari, had been referred to the Foreigners Tribunal Foreigners Tribunal Pokrajar for rendering an opinion as to whether she is a person who entered the state of Assam subsequent to 25/3/1971. Resulting in registration of case number K/FT/D/2782/12. The petitioner relies upon a voters list of village 2 Pastibari, Moza Golaganj district Dhubri, which contains the name of Dhirendra Burman, son of Nilakanta at serial 75, and that of Nirola Burman, wife of Dhirendra at serial 76. Before the tribunal, Nirola Bala Burman, wife of Dhirendra of village Pastibari, had been referred. And from the voters list of 1970 of village Pastibari, it appears that the name of Nirola Bala Burman appeared in the voters list of 1970, which itself would be sufficient to establish that the petitioner cannot be a person who entered the state of Assam subsequent to 25/3/1971. Accordingly, the petitioner is declared to be a citizen of India by further providing that she would be entitled to all the rights and liberties that may be available to a citizen of India under the Constitution. Petition allowed accordingly, sent back to you.
32,
Why the tribunal did not take note of this, Mr. Pai? What is happening, because of this kind of an approach, people will be losing faith on their opinions. At least if it is a genuine case, allow it. If it is not a genuine case, you don't allow. But if you approach, Either way, you will have to render opinion against. Ahmed Ali, who is the father of Ahmed Ali? Page number
Is
64.
both are there.
Village Dumoni, Govarbanda, Borpeta. Hurmut Ali Afan, son of Hunger, 60 is the father, 71. And which document will show Ahmed Ali is his father, my son?
It is 66.
Is
Totally from 1985 10 million. Here, Umutali account and the city number.
Ahmed Ali.
Yes, 464 Ahmed Ali.
We send it back. Okay. Tribunal will verify whether the person who is referred is the Ahmed Ali Afando of page 67. Because Ahmed Ali Afando of page 67 is a citizen. Only question that will remain is whether the referred man is that Ahmed Ali. But Mr. E.F. Sigdas and counsel for the petitioner also heard the petitioner Ahmed Ali has been referred to the Ordinance Tribunal number 10, Borpeta, for rendering an opinion as to whether he is a person with the state of Assam subsequent to so. The petitioner relies upon the voters list of 1971 of village Brumoni, Moza Govarbanda, district Borpeta, which contains the name of Hurmut Ali Akan, son of Kangalu, at serial 16. The petitioner also relies upon the voters list of 1985 of village Brumoni, Moza Govarbanda, district Borpeta, which contains the name of Hurmut Akhanda, son of Kangalu, at serial number 460, not 460, 450, and that of Ahmed Ali Akhanda, son of Hurmut, at serial 464. If the petitioner who is referred before the tribunal is Ahmed Ali Akhanda of the voters list of 1985 of village Dumani, the petitioner has established his has previously established that he is a citizen of India. Considering the above matter, remanded back to the tribunal to examine as to whether the petitioner who is referred and Ahmed Ali Akhanda of the voters list of 1985 of village Dumani are one and the same person. Something is there. What is there? Sorry.
Last part.
Hmm.
In the case of an act of by one of the four high courts,
As per we are reading that as per contention made in the additional written statement. That was
the name of his father, figure of his sister, head of his home, and even the name of
what is most interestingly. But how does it matter?
personal ownership. Whereas when we have given a statement, it is not a in the tribunal. Given the proper.
No. So we therefore we send it back to the tribunal to determine whether the referred man and What? And Hamid Ali of 85 list is the same person. You determine this. If it is same person, he is established. If it is not the same person, he could not establish. Because these people sometimes, here most of them are not very different people. And
at least is other than how many sisters did you have? It cannot be quoted by a person.
but Mr. Pine, once the burden is discharged, that this is my name, 85, my father's name in 85, my father's name appeared in 1970. It is for the state now to discharge their burden to show that he is not the same person. Nothing like that. Nothing like that.
I say my father name is A. In the next stage, I say my father name is B.
So therefore, you determine it.
That's why I'm just pointing out.
Here, in doing so, the tribunal may also take note of the contents in the last paragraph of page 78 of the writ petition, which is a part of an earlier order dated 5/1/2019 of the Foreigners Tribunal number 10 Borpeta in FT case number 162/27. That's what it says. 78 in my petition. 78. So you take note of that also. If the reason or the same.
33.
It's provided as a package. Once we are sending it back, you are protected till the reason of the request. 33. We'll come back at 2. Take more. I think 2 or 3 minutes more. Wait, listen. Come back.
$33.
Yes. Sorry.
It's producing a school certificate of 94. It was before the tribunal lottery. He's relying on this now.
So let him go and examine that man as per law. Heard Mr. Moti, then counsel for the petitioner also read. So what I'm making by a burden for law department. The petitioner Abu Sama had been referred to the Foreigners Tribunal number. Tribunal number 5. Of which place? There are 5 Borpeta for rendering opinion as to whether he is a person who entered the state of Assam subsequent to 25 to 1971. First sentence get the last part of the order. Every order is more or less the same language. So just put it up. Only the middle part is different. Resulting in registration of case number so and so. Case number so and so. It is a order. In this writ proceeding, the petitioner relies upon a school certificate dated so and so issued by
headmaster,
issued by the headmaster দক্ষিণ ক্ষুদ্রকুশি প্রাথমিক school dated 4/4/1994 to establish that the petitioner is the son of Siraz Ali of village Kudrokusi, PS Bagbor, district Borbeta. The petitioner claims that if he is able to establish that he is the son of village so and so, and the name of so and so having appeared in the voters list of
One voter is petitioner and his mother nearby.
no, just tell us only one.
In the voter list of
1966.
grandmother, 66 grandmother, 1971.
Okay, you start arguing. I wanted only a small, simple information where the name of your father is there. I would have completed my order.
1971 voter list, village management. But in the voter list of 1960, and again divided by group fire. And some Boda is set.
Petitioner seeks to rely upon the said school's information school certificate to establish that he is the son of Siraz Ali of village Kudrokusi. For the limited purpose, matter remanded back to the tribunal to enable to allow the petitioner to exhibit the said school certificate and also bring in the evidence of the headmaster of the school, who may depose as regards the content of the certificate from the original records of the school by exhibiting it. Further, the tribunal may also examine the aspect as to whether the school certificate indicating that the petitioner is the son of Sir do establish any linkage with any person who may be an accepted citizen of India. Okay, well, we're keeping it open. Petitioner to appear before the tribunal on so and so. And any order that may be rendered by the tribunal, if it is in favor of the petitioner, shall prevail over the earlier opinion dated so and so of the tribunal number 20. And if against, consequence under the law shall follow. Till the reasoned order is passed, no coercive action against the petitioner, the LCR be set back immediately.
Item 34.
34. Punu Nessa. Who is the father? Who is the father of Punu Nessa?
Rasamali is the father of the petitioner. Consider because you the father of the petitioner the name of the petitioner is on the voter list 1966 and 1970.
Which page? Which page?
Basically, and party.
Which document will show that Jasamali is the father of Punu Nessa?
Let's see. Kamura suddenly there is a case number. Case number.
How much is the father as a
So, what is your certificate? Circumcision. Under the law, what do you mean by a certificate? What do you mean by certificate? Legal meaning of the word certificate. Sorry. No. What is why a certificate is issued? The recognized authority, namely the Gambura, why a certificate is issued? Certificate is issued to establish the existence of a fact, right? So, what existence of a fact is established by this certificate?
Is the daughter
Daughter of Dasanan. Of which village? Chodara. How did the Gambura came to know? Because he is a Gambura of what village? So how does he know? How does he know this fact, that this fact exists? Was the Gambura examined? No. No, which page? Any other document other than this Gambura? Because if it is a Gambura certificate, a further question will remain whether the Gambura knows about this fact or he does not know about this fact. Do you have any further material? Marriage certificate, school certificate, those are better having better evidentiary value.
even for a long day, petitioner and community with us.
So you communicate with the petitioner, tell us. The person is a married person, lady, I believe. Do you have the Kavin number? The Kavin number, see if it is available. Ask the petitioner whether she ever went to school. If she went to school, whether there is any school records available. These are better material. Merely because one man who happens to be Kambura signs one document, that does not mean the facts exist. It has to be fortified with some further materials. The petitioner seeks for an adjournment to explore as to whether any material is available, which may indicate that the petitioner Punu Khatun is the daughter of Jasim Ali of village Chautara, whose name appears in the voters list of 1966 and 70 in respect of village Chautara. After 1 week, it's list after.
35.
Madam Verma, what did the Supreme Court provide in respect of a Panchayat certificate and a Gambura certificate? What is it provided? That it can. It was for the purpose of NRC. No. What is the evidentiary value? Suppose a certificate is given. Does it by itself prove the existence of a fact, or there is some further requirement to explore? by the person issuing the certificate, even the panchayat.
Married women, we had a difficulty that because we came in the village, the family tree and it was not having, the government issued a notification that the panchayat will be able to.
And this case, Mother, is not able to have any.
Page number 20.
Library grandfather. And school government grandmother. Next, Mother,
Just a minute. Sair Ali.
library
Naib Ali is the father,
grandmother.
grandfather. And the
School government grandmother.
and Tulizan Nessa is the
Grandmother.
grandmother. And who is the father?
Next, seventy of the grandfather and grandmother. 70 the mother, 24 father,
70,
24
24.
grandfather, library and father.
For Naib Ali and Tulizan Nessa.
Library, other men.
Hayat Ali is the father.
Yes.
Son of Naib.
Father.
And the Malika mother and petitioner is Hamida. Which document will show Hamida and Hayat together?
Other responsible from.
Where is it? Page 40.
Secondary, my phone.
Yes. We see. Was he cross-examining?
Yes, sir. Yes, 59.
Yes. Why the father's evidence is to be discovered?
My father is not there to that.
You want to adjourn it?
I am sitting down because I thought it was.
Adjourn on the inconvenience of MSA was not also for the home department. This now after we.
36.
Is 70, 35. Hussain Ali. Rubzan is the mother, stepmother. 66 more. Would be there. Yes, and the petitioner is Regina. Which document will show Regina is the daughter of Hussain? Page number. Has the headmaster been examined? Because school, I find this one school certificate and the cabin number to be good document because these are public records. All that you have to produce is the exhibit a public record and establish the fact. Vis-a-vis the statement made up by some individual, whether it's a Gambura or a secretary or whoever it is. J. Islam, J. Law Scholars. Mr. J. Law Scholar and also the petitioner. So what is the petitioner Regina BB had been referred to the Furnace Tribunal number. Furnace Tribunal number 1, Kamrup, bracket rural, for rendering an opinion as to whether she is a person who entered the state of Assam subsequent to 25/3/1971. The petitioner relies upon the voters list of 1966 of village Lohira, Moza Pub Somoria, in the Kamrup district, the police station Kolahari in the Kamrup district, which contains the name of Hussein Ali, son of Soto, at serial 2443. The petitioner also relies upon the school certificate of Sotrapara Ideal High School issued by the headmaster, which contains the information that Regina Begum is the daughter of Muhammad Hussein Ali of village Sotrapara. Sotrapara, but this is Lohida. Sorry, 85. 85. Although in respect of the voters list of 1966, although the voters list of 1966 is in respect of village Lohira, and Sotrapara and the school certificate of Sotrapara Ideal High School is in respect of village Sotrapara, by referring to the voters list of 1997. Where is Sotrapara word there? Referring to which is in respect of voting center Sotrapara and Consol and region. What is Consol region? Voting center, namely number 2 Lohira Sotrapara. Lohira Sotrapara. A contention is raised that Lohira and Sotrapara are one in the same village. Accordingly, the matter remanded back to the Forest Administrator to enable the petitioner to render the evidence of the headmaster of Sotrapara Ideal High School, who shall produce the original school records to establish the information contained in the school certificate relied upon by the petitioner, which is dated 11/6/1994. The tribunal may also examine the aspect as to whether the village Lohira and village Sotrapara are one and the same village. Upon doing the needful, the tribunal to pass a reasonable order, and if the reasonable order is in favor of the petition, it shall prevail over the earlier opinion dated so and so in case number so and so. And if against, consequence under the law shall prevail, petitioner to appear before the tribunal on date till the reasonable order passed, no coercive action against the be taken against the petitioner, send back the LCR petition.
Application for the advantage was not considered. It is not that
Let him produce. So therefore, Therefore, I ignored that submission. Now you produce.
I think allow there is any other evidence.
What evidence? What evidence? You bring in all kind of atrocious material and say the court has allowed you to do so. So tell us what evidence you want to bring. Will, if necessary, will allow you. Do you have any further material? This is a good material if you can establish. Why? Next slide.
Item 37.
Then more representation, those are names of the council. Yes, you have here. All over our victim. I know. Yes.
My lord. Grandfather need reportedly
Page number.
35.
Mehul Sheikh, son of son. Lakusi Bibi is the mother.
The grandmother.
Grandmother. Mehul Sheikh is the grandfather. Okay. 66 village, Mirwar Tari. So,
Case number 39, 1985 voter list of the father. It's one of the same village.
same village, okay. Then
Now we are, when we are linkage, my lord, please come to page number 24.
2024.
24. I know.
different Manohara events. Next week. Otherwise, I think we'll have to go in favor of this petition. Because birth certificate is admissible in evidence. It clearly mentions Manohara, son of Habez Ali of Mirwar Tari village.
Yes.
I think some exhibit A1. No, you don't have to prove a birth certificate. Because it is, I think what judgment is there already in respect of birth certificate. It's covered by the Evidence Act. As well as that registration of birth and death rules and that act. 1969 Act. All the three read together, this document need not be proved again. What to do? Declare him. Necessary again, send it back. Where is that birth certificate judgment? Some Das, Anima Das, Anita Das, something like that. See if he can get it now today. I think it's some Das, I believe. Anima Das, either Anima Das or something similar, something name. There, a detailed judgment was passed on the admissibility of a birth certificate.
For orders.
What is this IA for? Extension of time to comply with the order. Where is the order? 62. What is this order that you will 6671 stream? The partner to provide relevant mobile content. However, petition appear. What time you want to be extended? Sorry, where is the word 30 days? I shall appear before the SP within 15 days. That one. You did not appear. Unavoidable circumstance and no reason, both has the almost same meaning. See, there are few words under process, unavoidable circumstance. These have almost no meaning of its own. These are words depicting some existing situation. What is that existing situation? No, why you did not go and appear earlier? Madam Verma, we extended by another 30 days. Your name, Assam Sharma. Heard Mr. Assam Sharma, like option for the applicant, also heard Paki Sobreke. By this interlocutory application, the petitioner seeks an extension of the period of 15 days granted in the order dated 9/1/2023 in WPC 3497/2019, within which the applicant was required to appear before the Superintendent of Police Border Borpeta. It is stated that there was some delay in obtaining the certified copy of the order, which inconvenience the petitioner from appearing before the Superintendent of Police Border within the stipulated 15 days period. With the circumstance, this interlocutory application is instituted seeking an extension of the period granted to the petitioner earlier to appear before the Superintendent of Police Borpeta. The prayer of petitioner is accepted. A period of 30 days from today is granted to the petitioner to appear before the Superintendent of Police Border Borpeta by retaining all other conditions as provided in the order dated 9/1/2023 in WBC 3497/2019. In the event the petitioner does not appear, adverse consequences may follow. I allow as indicated above. Does not appear within the period of 30 days.
39.
We don't have the habit of taking up matters in hand. We'll take it up. Wait a minute.
39.
39. Another IA. Yes, madam, what is this IA for? Sorry, correction of which page? Sorry. Putting it off for time being, it's getting too cold otherwise. When you feel hot, you tell us. Yes, which page?
In the number 3, my lord.
No. In the order, which word do you want to correct? Which order do you want to be corrected? Okay, this is the correction in the repetition, cause title in the repetition. Which cause title? Page number 3. Shah Jahan Ali, son of late Iman Ali. It should be read as. Which is the correct one? Iman Ali alias Iman Ali Sheikh is correct. Earlier it was written Aman Ali. Third, your name? M. Nasrin. Heard MSN Nasrin, led counsel for the petitioner, also heard Baki views. Now, by this petition, the cause title containing the name of the petitioner in the disposed of writ petition, WBC 3435/2019.
By this petition, the constitution containing the name of the petitioner in the disposed of petition
is not formed. In the cause title in WBC shown into number so and so, the petitioner is shown as Shah Jahan Ali, age 52 years, son of Aman Ali, AMAN, alias Iman Ali Sheikh. It is stated that the correct depiction ought to have been Shah Jahan Ali, age 52, son of late Iman Ali, LP, late Iman, IMAN, alias Iman Ali Sheikh. Correction is allowed in respect of the cause title containing the name of the writ petitioner in WPC so and so. The writ petitioner shall now be read as name and description of the writ petitioner in the cause title of the writ shall now be read as to the is two, or just 20 years. Our hearing for the late Iman Ali Khaniko, Baki as it is. I allow that indicated.
I have 44 hearing.
Yes. Today, what do you want? Sorry. No, today what do you want? You have to get a matter heard. Mr. Hawk, we'll take up your matter after we complete the other matters.
Item 41 for motion.
40. Yes.
This trial is basically for implementation of the over part by the government of some participants to this earlier PI
So sorry, please repeat, for implementing the
implementation of yes
implementation of
section 12(1)(c) percent of the right to free and compulsory education act.
for implementing the provisions of section 12(1)(c) of the right to free education. That one. Okay.
That there was a PI for implementation of that. And pursuant to that, government of Assam has come up with an OL dated 2nd of September 2021. And page 25 is that OL. A very beautiful OL for implementing the provision of that state.
It's a beautiful one.
Yes, very
Then-
beautiful in letters.
Then why are you for the for
Implementation is not there because
page number 40?
page number 25.
25, sorry.
Yes, sir.
So you want it to be implemented.
Yes, Lordship, in the last scholastic year, because this came in the year 2021, September 2021, 2nd of September. In the last scholastic year, which is now the final exams are going on.
Where are you reading? Which clause you are reading?
This academic activity calendar is at relevant portion is at page 29, Lordship.
29.
Yes, Lordship.
No, ultimately the prayer is implement this OA.
Yes,
That's the only relief you want.
yes. Lordship.
Anything beyond that?
Yeah, immediately as per the activity calendar of this poem, Lordship.
No. We just want to know from you whether you want a simple order to implement this OM, provisions of this OM, or you want something beyond that.
So only implement.
Only that is good enough.
Yes, it is enough for us.
Yes, Mr. Mora, you want to say? It is your OM, perhaps pursuant to some earlier order in a PIL. Do you have any hesitation to implement it? Then we pass an order, implement it. If it's an agreed situation, you implement it.
As per the information of the petitioner, he made the survey in the town central district. We have found that no private schools and unaided private schools, they are not aware of this OA. 25% reservation for the disadvantaged section of the society, children who are belonging to the disadvantaged.
So we, as per the agreed situation, we'll direct them to implement it in all the schools.
Yes, Lordship, and as per the activity calendar, already 15th March every year, unaided non-minority private schools shall prepare the details.
Unaided non-minority public schools shall implement.
Shall prepare the details of entry level classes and intake capacity. The number 2, and it has to be done by 15th of March.
Today
Is 10th of March.
can you do it in 5 days?
So it's not.
Hmm.
This is the-
Why are you so late? Had you come about 10 days back, maybe you would have
Not sure.
asked them to give a compliance report also.
Not sure. Here, the petitioner himself has given representation way back in the month of April last year, the 22, for implementation of this
No,
code.
that's okay.
And
But you should have given us also some breathing space so that we can pass a more effective order and also ensure its implementation. But now we can only pass an order, but we are unsure of
that is,
ensuring the implementation. That's what we ask.
I number 3 of this code,
The appropriate government.
the issue of notice by state education.
Page number.
Page 29, Lordship.
Yes, please. The which OM you want to implement, 25 or 29?
This is the continuation of
It's
the
the same one.
same word. Activity calendar, point 3, Lordship. Figure number 3. Issue of notices by the state education department and schools announcing admission under Section 12(1).
So you want this notice to be issued.
Yes, so.
Mr. Bora, you issue it.
17 days.
Today is Friday. Tomorrow is a working day or a, and what is Monday is
13.
30. On 30 you issue it. Otherwise it will become futile. If you have formulated the good guidelines, which is also in conformity with the requirement in law, you also give the benefit of those guidelines and implement it. So what we provide is that requiring of issuing notice by state to be done within done on or before 13th, and the rest we pass a general order. You implement the requirement of the scheme. Even more than that.
That is PRB pending, and that will then take as an interim prayer. Because on 17th of March, they have to.
But an interim prayer always has to be something less than the final prayer, final order. And your final order cannot be anything more than this.
Because they have to give it in their website. So last scholastic year, what they have done is not there in the website. Still yet. Where is there?
Final regarding compliance.
No.
So what are we doing? In the interim, we make an observation as these guidelines are framed under section 12(1) of the Right to Education Act, and there is a order of the court in a related PIL to do so. In the interim, we say that we comply with the provisions of the OM. Also take note of issuing notice by the State Education Department before 17th March. Do the needful. And in the meantime, you file your affidavit. But it will be inconsistent. This will be a final order. But this will this not be a final order to keep it?
This 2021 and very nicely and very beautifully it has come up. The State Education Department shall officially announce page 27 launches Part B admission procedure under 12(1)(c). We are educating this only this section before in the PRF before launching.
Which one?
Page 27.
27 years.
Part B admission
Part
procedure
and
under section
Pre-seat.
12(1)(c).
Unaided minor examiners who shall display the total number of pre-seats available at
Are we on the same
the
page?
day. Yes, it appears. So. They are officially announced about the issuance of the
Websites. These are newspapers, reliable media.
So yes. So you want us to specifically mention this?
22, the whole year launch. Nothing happened. They did not even, not a single school had a single child under the 12(1)(c). Dr. K. Goa launches attention to one more document also, page 52.
Wherever no, there is no difficulty in hearing it. But if we hear and put in more aspects in our order, then we have to hear them in detail. But understand, but that doesn't mean, but that will not mean that on the very first day it is moved.
Something else that when we set up the website last night, no website is there for 12(1)(c).
Okay, you put up in it.
Some of the ability that we have it also, maybe we may it also.
If not put up, you put it up.
It's only 1 year have gone.
No, we understand. we are not against this PI. What we are saying is, if we put in too many aspects in our order, but if you want a agreed summary order, we can pass it today itself. If you do, no, understand. We believe in what you will do. But if it is not done, for this year also, everything will become futile. So just for this year also, the entire effort will be futile. So that's why I'm putting it. We can do one thing, we can pass a final order. We refer to the earlier PL order, we refer to the section 12(1). Also, we refer to this OM. OM, maybe a few of the requirements we'll extract it in our order, that these are the immediate requirements. Do it. And regarding the issuing notice under that page 29, that cutoff date is 17 March, do it before that. And regarding this page 27, what has been pointed out, that clause 3 shall officially announce issuing you put it up in your website by 13th Monday, because this is a requirement. It's your own requirement, not that if there is any adjudication on that. And the rest, you do it as per the requirement of the scheme. So this is the final order. Therefore, 13 is a Monday. And Monday you work from 10 o'clock to 5 o'clock. It's good enough a time to be everything. Mr. Bora, if you can take up 50-60 matters from 10:30 to 4:30, why your department cannot put up a requirement of the law in their website? Get hold of the expert. And your department must be having more number of experts, not just only one man goes to do these things. Verma, they are not contesting your claim. To say, then we issue notice. No, if you want so much answers of why from them, we issue notice. You find your affidavit. Not interim, we are passing final order. Which one you prefer? But if you want the answer to so many questions, then we have to issue notice. We have to give them an opportunity to find the reply. So you take your call, which one? Okay, 13th, we make it 14th. Or 15th, 15th, Wednesday. Because you have time up to 17th. On or before 15th, invariably and without any. Whose name should I put? You decide between the two and the heard for the petitioner. Also heard. Who appears to the government of Assam, Chief Secretary. Mr. N. Das for respondent number 1. Elementary to give your name, please. A. Das. Das for respondent 1, Chief Secretary to the government of Assam. A. Das for respondent number 2, Commission Secretary to the government of Assam in the Elementary Education Department. 2, 3 to be done. Commission Secretary and Secretary. 2, 3, 4, 5, 6. But take it. Here you do authorities under the and Mr. S. Bora for respondent 6 being the mission director, Samagra Shiksha Assam. Right. Yes. Who instituted the earlier PI? Same person or somebody else? Same person. Where is the reference to that order? Page 20. 20. Page 21. This is under the right, Assam right of children to free education. Assam right to rules. Rules. Responsibility. The petitioner Devargor Roy had instituted TIL 66/2020, seeking for a direction to the authorities in the government of Assam to ensure proper compliance and implementation of the requirement of section 12(1)(c) of the Right of Children to Free and Compulsory Education Act 2009, referred as the Act of short review, comma, providing for admission of at least 25% of the strength of the class of children. Admission to the extent of at least 25% of the strength of that class with children belonging to weaker section and disadvantaged groups in the neighborhood, and provide free and compulsory elementary education till its completion. The petitioner raised the issue that in many number of unaided non-minority educational institutions, the requirement of section 12(1)(c) of the Act of 2009, that 25% of the strength of that class be admitted by children belonging to the weaker section and disadvantaged group in the neighborhood, and to provide free and compulsory elementary education till its completion, had not been duly complied with. Having considered the various provisions of the Act of 2009, as well as the right of children to free and compulsory education rules 2010, as framed by the central government, comma, but this is an interim order. It's again list on 5/1/2021.
This,
Page 32. This is the final order. So we having taken to the note of the various provisions. As recorded in the order dated 18/11/2020 in PIL 66/2020, comma, the final order therein dated 16/9/2021 was passed. Full stop. In the order dated 16/9/2021, the court took note that as submitted by the Learned Advocate General Assam, comma, the government had already issued the necessary office memorandum on 2/9/2021, laying down the detailed guidelines as regards the benefits which would be offered in terms of Section 12(1)(c) of the Act of 2009. Accordingly, by the order of 16/9/2021, the PIL was closed as nothing remained for any further adjudication. But by providing that if any person has any grievance with the implementation of the policy contained of the policies or guidelines contained in the office memorandum dated 2/9/2021, it will be up to such person to approach the appropriate forum for redressal of the grievance. Full stop. In this respect, the writ petitioner states that for the purpose of implementing the policies or guidelines contained in the office memorandum dated 2/9/2021, where are the representations? The representation dated 27/4/2022 had been made to the Director of Elementary Education Assam. Full stop. A further representation dated 2/5/2022 had also been made to the Secretary to the Government of Assam in the Department of Education. This PIL petition is instituted by the PIL petitioner Deborgahar Roy, raising the issue that although the policy and the guidelines had been framed and provided in the office memorandum dated 82, but effective implementation of the same had not been made as yet. It has been specifically pointed out that in the policies or guidelines contained in the office memorandum dated 2/9/2021, in clause 3 of part B thereof, it has been provided that the State Education Department shall officially announce about the issuance of admission forms under section 12.12(1)(c) of the Act of 2009 through its websites, regional newspapers, and reliable media, and that the application forms can be received free of cost from the respective schools, and the filled-in applications be submitted to the respective schools along with requisite testimonials. And further, that the respective schools will design the application form as per their rules incorporating the following information. Page 27 of name of child, parent, and details to be assigned, bank name and branch of the Stop. He specifically reference specifically referring to clause 2:, which provides for the language. No,
Schools will design
no,
their
it's
education
it's a long sentence where it started.
It has been specifically pointed out that in the policy guidelines contained of this number 21, in clause 3 of part 5 thereof, it has been provided the state education department.
It has also been specifically it has also been specifically brought to the notice of the court that as per the table contained in clause 11 of part B of the OM dated so and so, comma, at serial number 3 thereof, comma, there is a requirement of issuing a notice by the state education department and schools announcing the admission under the provisions of section 12(1)(c) of the Act of 2009, and that the tentative date of issuing the notice by the state education department and the schools announcing the same would be 17th of March of every year. It is stated that for the educational, is it 2023 or 2023-24? It is stated that for the educational year 2023-2024, comma, as per the OM dated so and so, comma, there is a requirement of issuing the notice by the state education department as well as the respective schools announcing the admission under section 12(1)(c) of the Act of 2009 within 17th of March of this year. But in spite of such a requirement, the notice has not yet been issued. Apart from the aforesaid two specific grievances being raised, the general grievance is also raised in this petition that although their guidelines stroke policy had been issued as per the OM office memorandum dated 2/9/2021, but the provisions thereof are yet to be implemented by the authorities in the Education Department of the Government of Assam, as well as by the authorities under the, what is that, under the Homogra Hika Assam. Mr. S. Bora, Learned Counsel for representing Learned Counsel for the Homogra Hika Assam, as well as Mr. N. Das, Learned Counsel for the MS.A. Das, Learned Counsel for the Education Department of the Government of Assam, candidly states that in terms of the order dated so and so, final order in PL number so and so, as well as in terms of the OM dated so and so issued by the Elementary Education Department, Government of Assam, there is a legal requirement on the part of the authorities to do the needful as provided in the policy guidelines contained in the office memorandum dated so and so. And Mr. N. Das, Learned Counsel representing the Chief Secretary to the Government of Assam, also is of the same, also takes the same stand that the Government of Assam also feels that there is a necessity to implement the policy guidelines contained in the OM dated so and so. As it is an agreed position of the parties that there is a requirement to implement the policy and guidelines provided in the OM dated so and so as regards the admission benefits to the unaided non-minority educational institutions under 12 months ago. In the last sentence.
That is the negative position of the party that there is a requirement to implement a policy guidelines provided in the Orange Document 21 as regards the admission benefits of the
As provided under section 12 bracket 1 bracket C of the Act of 2009.
It is a negative position of the party that there is a requirement to implement the policy guidelines provided in the Orange Document 21 as regards the
We accordingly direct the respondent authorities to do all the needful as may be required to implement the guidelines stroke policy contained in the OM dated so that the benefits provided therein are available to the children belonging to the weaker section and disadvantaged group by availing the benefit of free and compulsory elementary education till its completion be made available to such children for the academic year 2023-24. As there is a specific requirement under clause 3 of part B of the OM dated 2/9/2021 for announcing the admissions under section 12(1) bracket C of the Act of 2009 through the websites, regional newspapers, and other reliable media to be made by the State Education Department, as well as the requirement of issuing notice by the State Education Department and the schools concerned, announcing admissions under section 12 bracket 1 bracket C of the Act of 2009. On or before 17/3/2023 for the purpose of the academic year 2023-24, we also direct the State Education Department of the Government of Assam through its Principal Secretary, or who is the head of the through the Principal Assam to do the needful of officially announcing the issuance of the admission form under section 12(1) of the Act of 2009 through the websites, regional newspapers, and reliable media on or before 14/3/2023, as well as to issue the notice by the Elementary Education Department announcing the admission under section 12(1) of the Act of 2009, also on or before 14/3/2023. And further, the Elementary Education Department to also do the needful to ensure that the respective unaided non-minority schools be also required to issue the notice, said notice, on or before 15/3/2020. We give 1 day more to the schools. 15/3/2020. In view of the administrative position of parties, the PL petition stands disposed of with the aforesaid directions. Secretary, representative. Because every time we again it keeps on changing. I think this will be a good thing. And suppose the private schools they don't do, what will you do? Suppose somebody doesn't, the department will do, I know. Suppose somebody do not comply with it. What is the remedy?
It is punished under the act law.
In the event, it is further provided that in the event the elementary education department of the government of Assam does the needful as indicated above, but any such unaided non-minority education institution do not comply with the requirement, appropriate action may be taken as provided under the relevant provisions of the Act of 2009.
Item 46 violation.
Madam Verma, I think this requirement of this act, when some 30-40 years back, without there being any statutory provision, this was followed in most of the schools. Because we can always know that may not be 25%, but at least a good number of students, every school is to accommodate. Possibly over the years, those practices have been given a go by it.
It won't take us a bit much. After working on this a little bit more, we can coming up with some things. That's a very good.
Is item 46. Who is coming? I think he was here sometime back. Sorry. You can start. What is the matter of?
This is regarding part of what are you called? Against the parent who have been linked.
Sorry.
Ending the railway station.
Vending in the railway station. Okay.
They are not a minor means.
Minor
That is the minor level.
units.
Yes. This matter is actually by the vendors.
Some vendors, some in the railway station.
Yeah.
Okay.
So what has happened, they are vendors since last 35-40 years. I have never come to them. Now, 2003, there was an enhancement of the license fee. Then,
2003.
paying the license, enhanced fee, we put it on it. There was a district order. I wanted to, we were allowed to pay the existing thing without any expense. So this was ultimately this thing. But because this is in 2014, in between in 2008, again there was a there was a victory, there was a state pay.
What kind of items these people they sell?
They sell
Those samosas and dosas and all those kind of things.
The railway.
Suppose I go to the Rangia railway station. How much I paid for a samosa in 2003, how much I paid in 2008, how much I paid in 2018, and how much I am paying in 2023. So I think correspondingly the when fee will also go. Unless you say that it is highly disproportionate.
Now, while they second time also we need to pay second time. Both the
So now what is the issue?
Now it's still for the 80, they pay notice asking us to pay all the area. Since there was a revision. We didn't pay, we started filing.
No, when your petition was dismissed, then it warranted you to pay the enhanced rate. But there was some interim order.
There was interim order and while disposing of the present registration, the on the signature has interfered with the revision also on the ground that the IRCTC was asked to show what is the basis for this enhancement. And they failed. Then personally they got in category time they category code. Category code is the 2005 provided that there can be enhancement of 10%. So the on the signature interfered with the revision saying that no, this entire revision we cannot support, we cannot allow. But the 10%
You can limit it up to 10%.
by that my lord, we are ready to pay the 10% enhancement. But the on the signature has a 12% still further. Saying that things did not pay. Now, all your right to vend. The whole right is dependent on individual by the regime.
Their discretion.
Yes,
They may choose you, they may not choose you.
yes, and this is for the thing.
Where is that part of the order?
Definitely.
58.
There are 17 paragraph relating to 10%.
Understand, page 58.
Page 15, there are 9. This court also takes note of the fact to fight. Page 58. On page 58, there are 9. I'm reading on that. This court also takes note of the fact that by virtue of the interim order, the petitioners are continuing to ban irrespective of the fact that presently they have not renewed their license. It is the opinion of this court and accordingly clarified.
Yes, Mr. What do you say?
We are ready to pay this 10%. We don't think that is statement. That pursuant to this observation, because of my request, they have issued further notice. They have seen we are unable to pay now. It's practically true.
When was the earlier interim order? Because of which this situation had arisen?
That interim order we have been possibly annexed, but there is mentioned here. In this paragraph.
No, I just wanted to read the language of the interim order. What kind of interim order was provided?
So far as the court order is concerned, there is a statement of the merit state that we have to pay the existing and not the existing. So existing license we will pay.
No, this is what I am trying to ask you. Till this judgment was passed, was the existing rate being paid?
Yes.
You paid.
Definitely.
So, Mr. Chaudhary, if pursuant to an interim order, the existing rates were being paid and the authorities are accepting that payment, don't you think there was a kind of an implied extension of the agreement or contract or whatever it is? So, if we can bring in the concept of there being an implied extension, then possibly this part requires a little bit of clarification. Irrespective of the fact that they have not renewed their license. The petitioner continuing to when irrespective of not having renewed their license. So this observation, not renewed their license, can be substituted that there is some kind of implied extension because you are accepting it. like those, our distinct tenancy. Tenancy, the agreement is for 1 year. The tenant continues go and pay the rent. The landlord keeps on extending it, the man stays for 2 years. Then there is a kind of an implied extension of the tenancy. Can't we borrow the same principle? To be fair with these people.
Then we had some discussions and discussion about the rate proceedings and all. The subject.
No, if we just make it just a clarification of this part, and rest we leave it as it is. And regarding the payment of the enhanced rate after the dismissal of the writ petition, is there a requirement to pay the balance of the amount? Because they are paying the existing rate. In the meantime, there is an enhanced rate. There is an interim order that you continue paying the existing rate. So there must be a difference between the enhanced and the existing. Writ petition ultimately dismissed. Will the implication be that for the entire period, now you also pay the balance of the amount? If that requirement is there, that you also pay the balance of the amount, then the situation will be such as if the writ petition was never filed. And they continue to pay you the enhanced rate. So had it been so, bring it down them to that situation and you take a decision. And after all,
I can understand the situation now. What my level of this he said it happened to us.
What we have done with a
so what we do is we retain the order as it is. Only thing with regard to that they have not renewed their licenses, we'll just clarify that the principle of implied extension may be applicable. You look into it. 2, there was an interim order to pay the existing rate, and they continue to pay the existing rate. Writ petition ultimately dismissed. So now there will be requirement to pay the balance difference between the enhanced rate and the existing rate. If they agree to pay it, then the situation will come as if the writ petition was never filed. If we arrive at that situation, now you take your call that had they not filed a writ petition, what you would have done with them? You do the same thing to them. Can we pass this order? But Tuesday, what do we do? It will come up before the other bench.
Related matters. The same, there is the
No. What do I do with this one? Now I have substantially heard and arrived at something. So whether I should retain it with me or I just say as print for no, that call you take. And the whole idea is balance the equity. Balance the equity because the situation is such. Had they not been paying the existing rent, matter would have been different. They continue to cling on to their legal right. There is an interim order to pay the existing rate. Writ petition dismissed. The legal implication thereof will be you are required to pay the enhanced rate. Pay the difference of the enhanced rate. Once you do this, the situation will be as if the writ was never filed. So now we leave it to your discretion what you would have done with them had they not filed a writ petition and the position would have been as of today. No, not instruction. We don't need your instruction what you do. We allow you to do whatever you want to do. We are allowing you to do whatever you want to do by taking the situation as if the writ was never filed and they continue to pay it. If having done so, they have no right to continue, don't extend. If you, in your view, you feel they had a right, give the extension. And either parties will come before the court again. I think it's fair enough. It's entirely on you. We are not imposing anything. Only a little bit of clarification to the order of the single judge. That's all. Can we pass that order?
Yes.
Chief is having a single bench also. So I did it early. So let's heard Mr. D. Majumdar and senior counsel for the petitioner, also heard Mr. R.K. Chaudhary, learned DYSGI for the respondents in the Union of India and the authorities under the NFA. You also did. Okay, as well as Mr. Anik Singh and Anik Singh and Anik Singh, counsel for the respondent number 3 and 4, being the authorities under the Indian Railway Catering and Tourism Corporation Limited. How many appellants? 9. 9 appellants. The 9 appellants herein are where? Are stroke where? I put both because you don't know your present status. Are stroke where? Okay, are. Are all license holders to operate? What is it called? License holder to operate vending units, minor vending units in the Ramia railway station. And it is stated that the appellants had been in the business of operating the minor vending units for almost 35 years. For almost 35 to 40 years. Under the catering policies of the respondent railway authorities undertaken from time to time, the vending fees that the appellants are required to pay had been enhanced. It stated that enhancement was made in the year 2003 as well as in the year 2008. On both occasions, the appellants as well as other similarly situated vendors instituted writ petitions assailing the enhancement, where the common trend was to grant an interim order requiring the appellants to pay at the existing the vend fee at the existing rate. But ultimately, all such writ petitions were dismissed, resulting in the requirement of the appellants to pay the vend fee at the enhanced rate. An enhancement was also made, the latest one.
Not enhancement. All areas.
In the year 2018, the respondents in the railway authorities demanded the appellants to pay the area being the difference between the enhanced rate and the existing rate which they pay because of the various interim orders of the court. Being agreed, WPC, this one.
Yes.
Being agreed, WPC
739.
7339 had been instituted. 7339 2018 had been instituted. The writ petition 7339 2018 was given a final consideration by the judgment and order dated 23/1/2023. We also take note that in WPC 783 and other writ petitions also, it is 2018 writ petition, also there were interim orders allowing the appellants to pay the vend fee at the existing rate. By the judgmental order dated 23/1/2023, the writ petitions stood dismissed, meaning thereby that a claim of the respondent authorities in the railways requiring the appellants to pay the area difference between the enhanced vend fee and the existing fee are now required to be paid. Implication of that.
Partly allowed, third party will be allowed.
But however, a modification was made as regards the enhanced vend fee that is they are required to pay, to the extent that the enhancement would be limited to 10% of the earlier existing rate as per the prevailing catering policy of the respondent railway authorities. But however, in paragraph 19 of the judgment dated so and so, it had been provided as extracted. Being agreed by the provisions of paragraph, primarily being agreed by the provisions of paragraph 19 of the judgment dated so and so in WC so and so and other petitions, this regime is instituted. One of the implications of paragraph 19 of the judgment dated so and so would be that there is an observation that the appellants are continuing to vend, irrespective of the fact that presently they have not renewed their licenses. And accordingly, an opinion was expressed that the right of the appellants to vend would be dependent upon the licenses being given by the railway administration. And since the renewal allotment, the appellants would have no right to vend. Mr. D. Modimdar and the senior counsel for the appellants in the writ appeal had made a categorical statement on facts that although the respective licenses of the appellants may not have been renewed, but on facts, they continued with their vending business by paying the existing rate as per the interim orders. Accordingly, it is the submission of Mr. D. Mozumdar and Senior Counsel for the appellants that as the appellants are continuing with their vending business by paying the existing vending fee at the existing rate, there is an implied extension of their licenses, although factually the respective licenses may not have been renewed or extended. Although Mr. Ashidi Chaudhary and DYSGY raises an objection to such submission of Mr. D. Mozumdar and Senior Counsel, but on principle, we see no reason as to why the said submission should not be accepted in law. We take note of a particular factual aspect that although the licenses of the appellants may not have been renewed or extended, but the respondents in the railway authorities continue to accept the vending fee at the existing rate on a regular basis without raising any objection. meaning thereby that the appellants continued to with their vending business with the full knowledge of the respondent authorities, inasmuch as the vending fees at the existing rate were accepted from time to time as required. Although such acceptance may have been pursuant to the interim order of the court. Mr. R.K.V. Choudhury and US states that although the said acceptance was with the complete knowledge of the authorities, the responding authorities in the railways, but it was done pursuant to the interim order of the court. We are unable to accept the said submission for the reason that all that the interim orders provided was that as long as the petitioners are required to pay their vending fee, they would be paying it in the interim on the existing rate. But the interim order did not preclude the respondent authorities in any manner to act upon their discretion not to extend the license and also not to accept the vending fee. That is not there. Only thing interim order is not the, all that the interim order provided was that the vending fee should be accepted at the existing rate and not at the enhanced rate. So, although a stand was taken in the affidavit by the respondent railway authorities that because of the pendency of the court proceeding, the licenses could not be renewed or extended, but a said stand would also be unacceptable in as much as there was no restraint order in any manner from the court during the proceeding, disentitling the respondent authorities not to extend the licenses. Be that as it may, the factual aspect remains is that the appellants continue to pay the vending fee at the existing rate, and the respondent authorities continue to accept the same, leading to an equitable situation of there being an implied renewal or extension of the licenses, as no proactive measure was taken not to allow the appellants to continue with the vending business. Full stop. Mr. D. Mojumdar, Learned Senior Counsel for the appellants, also makes a categorical statement before the court that all the appellants are also in the line. Another aspect of dismissal of the writ petition, WBC Swens and others, would be that the appellants, that all the appellants would now be required to pay their vending fee at the enhanced rate, even for the period covered by the interim orders, enabling them to pay the vending fee at the existing rate. That's the requirement now. It is in your favor.
Yes, not produce any material on the basis of it. Therefore,
No, we are not disturbing them. We are not. Last week, that all other provisions will remain as it is. So we are not. Otherwise, you go on into issue after issue.
Then we are ready to pay 10%.
We are coming to that. People.
In the respect of dismissal of the petition, to ensure to pay that the applicant would now, the applicant would now be required to pay the and pay at the enhanced rate, even for the period covered by the interim orders. And
Mr. D. Mojumdar, Learned Senior Counsel for the petitioner, for the appellants, is candid enough and makes a categorical statement that all the appellants are agreeable to pay the enhanced the vending fee at the enhanced rate for the entire period, and for the purpose are ready and agreeable to pay the difference between the enhanced rate and the existing rate which they have already paid. If the appellants pay all the arrear amounts at the enhanced rate, being the difference between the enhanced rate and the existing rate, comma, the situation as of today would be as if the appellants had never approached the court, there was no interim order, and they have readily agreed to pay the respondents the entire dues at the enhanced rate, and they have actually paid it. If that is the situation, we now leave it to the respondent authority or respondents in their authorities in the railways to take their decision as to what they would have done had all the appellants paid the event fee for the entire period at the enhanced rate without raising any dispute, and we leave it at their discretion to do the needful as they would have done otherwise. In doing so, the petitioners be also given an opportunity, also given an hearing to arrive at any effective reasoned decision between the parties. NSP, applicable NSP. Till any such reasoned decision is arrived with parties, a status quo is on today, may be maintained, but with a clarification that the payment of the event fee would be at the applicable enhanced rate for the interim period. And applicable, all other terms of the judgment or the date in the previous order shall remain as it is provided therein, except for the modification through clarification as indicated above. So here you cover with your 10%. 35, 40 years, you see, this must be the second or third generation. And what will they do? Give them an opportunity. Assisted by Mr. S. does. And Mr. SP does, and Mr. N does. Nice. Timing. This is next week.